in chat. Yeah. Yes. Yeah.
Five minutes. Judges our time is same time, 4 o'clock. 3 தான் ஸ்டார்ட் ஆகுறாங்க. வரது 3:40.
பிரச்சனை நமக்கு சரியா
We'll go by the same schedule.
போனா சரி.
Yes.
இந்த லாஸ்ட் இது கொஞ்சம் பெருசு 45 minutes. ஓகே, மற்றது நான் குயிக்கா முடிச்சிடும்.
Right.
Okay, the next topic is mediation, law and ethics. Law is still yet to come on mediation. The bill has to be passed. We'll talk about the ethics. What do you mean by ethics?
Standards, morals.
Morals, yes. Sometimes morally correct is legally correct is not ethically correct. Sometimes ethically correct is not legally correct. So law is based on a lot of rigid stuff, but ethics is things to do with the mental attitude. If a mediator is directly involved in any case where they have personal interest or a professional interest, suppose a chartered accountant is also a mediator, is making money out of this person, it's a professional interest here. Financial interest, you should avoid taking that mediation work. Sometimes if it's direct, it's easy. If it's indirect, what will you do? What will be the indirect interest? No, what if if you have indirect, you're not directly having an interest. What will you have if it's an indirect thing? Suppose you're not interested, you're not involved. Maybe you're a director of a company, that company gets some benefit. That's an indirect interest. So you should avoid, you should disclose to the client. You should be competent at the same time as you should follow the professional boundaries. You should know the limits of your ability and you should disclose to the client that they're only up to this much I can do and I can't do beyond that. You have to tell the client your interest and how it will affect the mediation if you start playing. And you have to tell you won't be able to handle this because you have some personal interest, professional interest, or a financial interest, direct or indirect, or you are in some company which is making money out of this particular deal. So you have to disclose that kind of an interest. Impartiality. For in every profession, the ethics is that you treat anything without any partiality. Maybe a teaching profession, it may be a journalist, or it may be a lawyer, or mediator, it has to be very impartial. Instead of acting for such cases, if you think that it's going to be a partiality exercise, you have to avoid taking up that mediation case. Because it's a voluntary thing, people think that it's a voluntary thing that I can do what I want to do. No, but it's a profession by itself, and you have to, at some point of the time, you have to say, no, I'm not going to handle this. Even though it's a voluntary thing, I'm not making money out of this mediation. Still, my interest in other things is going to affect it, and I'm not going to work on that. The other thing is confidentiality. Within the four walls, you try to do the mediation, you sit and work out things. Then you go and talk to your family, or you go and talk to your friends about that. That's breach of confidentiality and privacy. Privacy Acts and confidentiality regulations are very strict in Australia, and you can't even tell your own family members what you did on that day with the client. As it's also, they have to inform the parties in any confidentiality issue raises. Suppose mandatory reporting, like if there's a child abuse, the doctors, nurses, lawyers are definitely, they have to inform the government about that. So it's a mandatory reporting duty we have, like nurses. They find any bruise on a child. So some kind of mandatory reporting are listed, and some professions are also listed. A teacher finds a child has a bruise, they have to report to the Department of Child Care and say that this is what's happening. So you have to tell the client in advance if anything goes against the law or mandatory reporting duty I have. Without telling you, I will report it. Do no harm. That's the basic principle. Abe also told about that. When you do the mediation, there may be emotional disturbance, people may be screaming at each other, and there may be potentially damaging psychology. And sometimes they also throw things at each other or on you. It happens all the time. So without any harm, you should conduct the mediation very peacefully. Self-determination. Party autonomy is one of the guiding principles, like, if a mediation is involved, each party decide on their own. It is self-determination. You don't determine things for them. You only guide them and walk with them through a pathway to identify issues, options, and tell them these are the things, but now, whatever it is. And they decide, and they have the self-determination on that. Informed consent. The other thing is, if they are agreeable for something, they agree after going through all the options, explained to them, the consequences, everything they identify. They are well informed about everything, and they decide based on their information given to them what is best for them. So it is informed consent. If you're not informed and you're blindly believing something and doing a consent, that's not acceptable. But in mediation, as a mediator, you inform all the best options and other things for them to understand, and they will decide and they give the consent. When they give the consent, it is considered as informed consent. Duties to third party. What do you mean by duties to third party? You settle something, that settlement is between two people, but after settling, you also identify that there's a third party involved. Suppose one house, you're trying to settle between parties and say, okay, you can sell it, take 50-50 and all. But there may be a caveat where one party has borrowed a loan or something. So if there's a third party involved, that has to be informed to the client, as well as the third party has to be informed what's been decided in the mediated. You can do it legally, okay? Honesty, that's the very basic things for lawyers or any profession, that you had to be a fair and full disclosure of the qualifications, what's the experience you have. If you're not experienced, don't bluff. I can do this mediation. It may be a complicated mediation and try to say, I have experience, I can do. I always do one thing. If I'm not having any experience in a particular area, I get an expert mediator and tell them that I'm getting an additional mediator. And this is what's going to happen because I am not having any experience in trust divisions and stuff. So if they have trust and there's a big 1 crore rupee or something, so I said I get a trust-related mediator who knows the trust issues, how it is divided, and also I would like to invite him. And you're right? Yeah. Okay. And if there's any fees payable, you have to disclose that in advance. Any other aspects like if you're getting a psychologist involved in a mediation, you have to say it's an expert mediation meeting and we need to get a psychologist involved because of the child, and whatever the fee payable is payable. Okay, any questions on that? Any questions? What are the ethics? That's the basic ethics of a mediator. The law we are not discussing because I will be going through after my last session will be on a legislative framework, where I will be going through the bill and give you the important clauses which speaks about the topics. Okay. Now we can hand over to community mediation to Mr. A. Any questions before that?
About the confidentiality.
Yeah.
You told us an example about children having a bruise. That should be, if at all there is an illegal thing that has happened, there should be an information given. So when there is a divorce case or a separation case that's going on mediation, and if the wife has suffered any sort of
domestic violence, I don't know what's the laws speak here, but where we have to report it. In Australia, any child abuse, domestic violence, elder abuse, we have to report it. Yeah. Even if you see the bruises, some regular things you see that you're suspicious about it, I have to ask and I have to put a file note. Then if it is a serious thing, I have to immediately report. If I don't report, I'll be fined $25,000. Even the nurses the same way, the teachers, school teachers, if they see the child is so totally withdrawn and if they are affected by child abuse and domestic violence at home and stuff, and if they have some bruises on their face or hand or whatever it is and they cry all the time, they have to get a counselor organized and they talk to them, and if they find that there's a serious thing going on at home, the father is not nice or the mother is not nice or mother has a mental illness harassing the children, they have to report, and if they don't report, $25,000 fine. That's a good amount, isn't it? $25,000. Yeah, it is a half year's salary for someone. Yes. I don't know whether Abe is ready. The next session is the community mediation.
Yeah, I am ready.
Okay. Abe, you can take over. Thanks.
Okay. I'm going to talk about the Australian model on for community mediation because it has been one of the older models that has been in operation continuously for the past 40 years. In 1991, the New South Wales government sent a delegation to America to study the community mediation model in America. And they came back after the study and presented the government with a report. And they decided to do a pilot project in 1992. That proved to be successful. And in 1993, the New South Wales government adopted community mediation as part and parcel of the system, justice system. Now, the Community Justice Center was entrusted to manage and the whole program. They recruited people who have no legal background, who have no other experience in mediation, but they were looking for qualities that could make them great mediators. And some of those qualities, ability to listen and connect with people and build a rapport with people. And their communication skill is highly regarded, and ability to diffuse situations. I applied for the job in 1993, and I had no background except in social work. And I was successful in that, and I have been working in the community mediations ever since. Community mediation really works very well, the model. And the reason that the government did it, because there was a speech by Judge Joe Harmon to the National Mediation Conference in 2014. He said, historically, Australia has been among the most litigious societies in the world. We used to take matters to court for everything. And the burden, financial and otherwise, on litigants was severe. The public money spent was severely strained by the necessity of allocating huge resources in terms of infrastructure and personnel, like judges, juries, facilities, and support staff, to the hearing of all these cases. In the late 1980s, the courts decided that the days of litigation being conducted at whatever leisure pace the protagonist chose were over. Case management became the weapon of choice, the judiciary in its quest to confine cases to real and relevant issues and compel litigants to conduct litigation quickly and efficiently. Compelling parties to settle those cases that should be settled as early as possible, and to seriously address issues of resolving the more challenging disputants were both philosophies at the center of the case management drive. It is no accident that the rise of mediation in Australia coincided with the rise of case management and its underlying philosophy. Now the courts and the parties are very much focused on alternative resolution, with mediation in the forefront of that push. We transitioned from being dependent on the court system in resolving conflicts to alternative dispute resolution. And that's the reason for this. And the outcome for this transition and change and being focused on litigation to alternative dispute resolution and practices, there has been improved in financial wealth distribution being more even. We have a middle-class society that emerged back in the 70s. Workforce fueled the greater social freedoms and more liberal attitudes. Non-traditional commercial transactions, exposure to non-Anglo cultures, because we have over 170 cultures in Australia. And workplace disputes were more evident because we had a very active unionized workforce. The land rights with our indigenous people, and the multinational complex commercial disputes. And we have a lot of mining companies, international multinationals. So the new social and legal reforms and the emergence of affluent middle class and the indigenous people's demands for land rights warranted a new approach to resolving disputes. Litigation was seen ill-equipped and not suited for disputes that have individual or group interest. Sorry. Australians value relationships, and litigation is seen, and in majority of court cases, destroys relationships, or at least damage the relationship between litigants. On the other hand, mediation is seen, and in majority of cases, is a relationship builder between parties and in conflict. It's been said, next to the United States, Australia has become a global forerunner in mediation law and practice. Mediation is officially seen in Australia as a preferred, cheaper, and a quicker alternative to the traditional court litigation. There are a number of and variety of legislation acts providing for mediation. Outside the courts, a whole mediation industry has been established. Back in the 80s, there were only a handful of people who were doing mediation. Now, every law firm in Australia either provide direct mediation services or partnered with a mediation service. We have many individuals practicing mediation, as well as many organizations as well. Australia is well known for being a nation of early adopters of a new technology and systems. Australia adopted the American model of mediation in the late 70s and early 80s. The Australian courts were quick in adopting and incorporating mediation into their court system. The Australian government has funded many groups and organizations who provide mediation services. The Community Justice Centre is fully funded by the New South Wales government, and they provide a free mediation service to any person who seeks mediation. The courts in New South Wales all have connection with the Community Justice Centre, and they may actually have resident mediators in court houses who are taking those cases. And this has proven to be a very successful practice. The benefits of mediation at the community level, it's low cost or free. Low cost if they go private, and free if they go with the Community Justice Centre. It's fast, confidential, outcomes owned by the parties preserve or commence in new relationships, parties able to express feelings. You can't express feelings in court, court only interested in facts. Parties deal with the issues directly with each other in a safe space. It is an informal, flexible, and the dispute is owned by all parties present, and parties determine the outcome. It is there, and that's why it's been found 90% of outcomes or agreements reached in mediation are honored and respected much more than court orders, because the parties feel they actually worked and participated in its formation. Mediation is not limited to resolving conflicts with the assistance of trained mediators. Conflict resolution skills are now a requirement in every senior management position in the private sector and in government jobs. They are actually in schools as well. Peer mediation is very, very strong in Australia. And we have peer mediation programs in many schools in Australia. And we actually encourage peer students to resolve their conflict in the schoolyard much better. So, in saying mediation and conflict risks are essential to all of us, we all experience challenges and conflicts in our daily life. Most conflicts are caused by the language we use. Conflict resolution is about communication. The way we communicate our grievances and complaints determine the outcome. If we are positive in our communication, we are most likely to achieve positive outcomes and maintain a better relationship with each other. Thank you. Any questions, please? Okay, I'll wait for Chandrika.
She will connect you soon.
Are you done?
Yep,
Yeah, okay. Thank you very much for that. Yeah.
thank you.
Yeah. Okay, so we're coming to the last part of the program, which we are supposed to start at 3 o'clock, but we're a bit early today. Legislative framework, and then we'll have a little question and answer and session to Aurangzeb, we connect. This one. Okay, how many of you have heard of mediation bill? What does it aim to do?
Or BS, yeah. Production of implementation of mediations.
So how does it implement? Is it a mandatory one? Because if the courts are filled with cases for so many years, it's more than a quarter century, the paperwork is still pending, nothing is achieved. You go to a court for a property settlement, it takes about nearly 1-2 generations time. So what they are trying to do now is most of the stuff you try to organize your mediation and finish it off, or at least most of the stuff by mediation. You mind me sitting and doing it? Okay.
No, sir.
So they're passing the bill. It's under the public review stage. I've also given some of the feedbacks. So that's the scenario there. But initially what happened is in 1908, the Code of Civil Procedure, which is enacted to introduce mediation in India. That was the first time they introduced, it's about in so many years back. Section 89 of the CPC together with Order 10 Rule 1A mandated civil courts to refer disputes to alternative. There's already existing something, but nobody follows it because one thing is the lawyers don't want that. The lawyers would like to have litigation, which is money. And the other thing is even the clients, they feel, no, I want justice. I won't go and fight and get my right things and stuff. So that kind of a thing is identified as court-referred mediation. Arbitration Conciliation Act 19. Somebody asked me a question: what is the difference between conciliation and okay? Conciliation is it's a court director. The conciliator will direct, and you have to take it. But mediators don't direct. Mediators only give you option, and you choose. It is self-determination thing. And that was adapted regulating the procedure for appointment of the mediators for the party seeking to settle any dispute using a mediation without any court procedure. So that was already in 1996 Arbitration and Conciliation Act, that you can go to a conciliator and sort it out without going to the lengthy court procedures. Then Mediation Bill 2021, which is under process now, it's under the public review. I don't know how long it take a public review for any of these acts in this country. Any idea? It started in 2021, 1 year gone. We are in 2023.
There's no time limit, but normally they won't. After that, Parliament enacted, they will have discussion.
Yeah, it's under the review process.
Normally they put the time limit. It's not.
Okay. It acknowledges both domestic and the international mediation. What do you mean by that? What is your understanding about it? You think that somebody from Australia will bring a matter to India to sort it out by mediation? No chance. Okay. What do they mean by international and domestic mediation?
Private conflicts of internationals, like.
If they have an issue with an Indian company and say Taiwan company, you can commence a mediation here. Because it allows, even if it's an international related affair, you can still do the mediation here. That's that was given, that option was given by Singapore Convention. And it also lays down the matters outside the scope of mediation while recognizing online mediation. That's the main thing in the beauty of this bill. They are insisting that don't waste your time. You just do online mediation and finish it off. That's what Mr. Saravanan is trying to organize, a platform where people can do online mediation. I would prefer to do, because most of my work nowadays I do online, all the court work. Most of the divorce matters and stuff, it's all online. Now it's easy for us, you just go on that time, 15-20 minutes, so you can finish it off. Then mediation, we do, myself and Abe do a lot of mediation online without meeting the parties thing, and a lot of document signing also now they allow you to do online if you have the DocuSign, and you have to have a video of what they are signing. You have to keep that record of that, and things are made very easy to do online. So the same way, online mediation is very popular nowadays in other countries, and it is slowly coming to India. But again, with the written consent of each party, both parties at any stage of the proceedings, video, audio means, and when you record video and audio of those things, you have to follow the privacy laws, confidentiality issues, and all the other ethical things you need to follow, and you can't expect somebody to steal the stuff and give it to the other party or something. Section 2 defines the mediation. All or both parties habitually reside in or are incorporated in, have their business in India. That means it can be parties or businesses. They are in India or incorporated in India. The mediation agreement provides that the Mediation Act 2021 will apply to the mediation. And the mediation and international mediation, when it goes, it's defined in 3C. Even at the time of conclusion, and one of the party is an overseas person. So then you can consider that as an international mediation. An individual who is a national of or habitually resides, that usually resident in any country other than India. Body corporate, that means a business, include limited liability partnership or any nature, with its place of business outside of India. An association or a body, individuals whose place of business is outside India, or a government. Even you can have a mediation with the government. You may have some issue with Korean government in supplying something. So you can have one party is not in India, still you can do an international mediation. 3I defines the mediation service provided as a body or organization, can be a company, business, or a person that provides for the conduct of mediations as in place in procedure. Lok Adalat constituted under National Legal Service Authorities at 1987 and mediation centers annexed to court are also included in the term mediation service provided. What they have done already, the existing system, they are just incorporating into this act so that everything is covered. Section 6, it says, civil commercial dispute must take steps to settle their dispute through the pre-litigation mediation. That's the key word. Before going to the court, pre-litigation mediation before approaching the court of law. Additionally, the court and tribunals are proposed to be given powers to refer parties to mediation and pass suitable interim reliefs to protect the interest of the parties to a court case pending completion of mediation proceeding. What's meant by that is the courts and tribunals are given powers so that they can decide. So they can always say, I'm referring this party for mediation and make some interim reliefs to protect the interest of the parties. The courts have the powers to say that I'm only referring this to mediation, they need not come here. Okay. Section 6.1 is make the mandatory for the parties to take steps to settle disputes pre-litigation mediation. And then again, it is mandatory to complete the mediation proceedings within 90 days. And on both parties' agreement, they can further extend to another 90 days. Totally within 180 days, they have to finish it off. Section 12 and 13. 13 provides a mechanism to terminate the mandate or mediate the case, and there's a justifiable doubt as the mediator's independence or impairment. If the mediator is not fair enough, or if you feel it's dodgy and there's some impartial things are going on, you can terminate that. Mediator appointees can be from any walk of life. They can be independent and impartial. They should always give if you feel that they're not okay, you can terminate them. Section 20 stipulates a period of 90 days and further 90 days, which I spoke. Section 21 defines mediated settlement agreement, which is very important. MSA, to me, include an agreement in place as an interim agreement in writing between the parties, which settles some or sometimes all. It need not be all. Sometimes it's only few you are going to settle out of 10 items. Still, it can be whatever you're disputed, you can have a mediated settlement agreement and the rest can go to the court. The proposals
That can be executed.
Yeah, that can be executed. That's why, because if once you're done that part, out of 10 items, 5 items you have agreed, that can be executed in the court. The 5 items which are not decided, you can go and fight in the court. As any disputes shall be final and binding. That's why it's meant by executed. Once it is signed by the parties and authenticated by the mediators. That's the clue there. If you have agreed on something, 5 items you sign and the mediator signed it, it is the final version.
It has a value of arbitral award, like an arbitral award.
It's not an arbitral award. The mediation is totally, it's like arbitral award. It is a final decision. The court will accept and say, give orders that it has to be executed.
So equal to judgment and decree.
Yes. 23(1)(3) is confidentiality. It speaks about the confidentiality. Maintain the confidentiality of a dispute. Documents produced and during mediation will not be admissible as an evidence. Once you have done so many things and you talk to each other, you disclose some of your private stuff, then they disclose some of the private document. They all agree for this agreement. All this document will be sealed. You can't go to the court and say, I've disclosed some of the issue. In the document, I saw that she said that she has $10,000 in the wallet and say that I want that document come to court. No, it is sealed, done and dusted. It can't be taken to the court, any court or tribunal. However, this can be somehow problematic when it will be problematic that you can't produce those documents. If it's a key document, and if it's something to do with the illegal things, and you can always, if the failed mediation, especially failed mediation, it can be brought to the court. You can demand it come to the court. 28 and 50, recognize mediate settlement agreement, domestic and international mediation, final and binding. Section 29(2) is always an aggrieved party to challenge the agreement, that you can challenge it. After you do something, if in a court or a competent jurisdiction, only on few grounds: fraud, corruption, gross impropriety, or impersonation. So all these things, if it's something wrong, you can go and challenge. Something is not legal, you can definitely challenge. The parties applying for enforcement shall approach the respective high court with a settlement agreement as a normal procedure, attested copy of the same along with any other evidences you may require to prove that settlement agreement is covered under Singapore Convention. So Singapore Convention is the main thing which allows this kind of an inclusion in the mediation bill. Mediation council is going to be established. That's one of the things in that bill. And the members of the council are proposed to be selected from Supreme Court of High Court judges, eminent persons, and academicians in the field of mediation, and key government officials will be managing the Mediation Council of India. Chapter 7 talks about online mediation, where pre-litigation mediation conducted through apps and computer networks. At any stage, mediation parties can opt for online mediation. We do a physical mediation, and then you say that I'm going to states, I can't wait here, I'll go to states and we'll do an online mediation. That's fine. It can be a hybrid mediation from state. Lok Adalat and permanent Lok Adalat can be also conduct mediation proceedings in accordance with the provision of the Legal Service Authorities Act 1987 and the rules and regulations made there under. So they have to follow their own rules, but still they can conduct the mediation. Wide powers to the parties. What do you mean by wide powers? The parties decide. Parties say, no, I want this mediator. No, I don't like this mediator. He is very partial. I'm not happy with this mediation. I want to get out of the mediation. I want to do online mediation. So they have choices under the new bill. Before the commencement also they can do, throughout the commencement, before the mediation end, any stage they can change things the way they want on a mutual agreement. Any conflict, as I said previously, they have to disclose in writing before the commencement of the mediation process. Normally in any country, that's the procedure. If you're in any board, I'm in 2 boards in Australia. One is the Medical Hospital Board. I'm one of the directors. One is the Multicultural Board. So every time there's an election, some of my friends who are ministers and MPs, they ask me to come and stand for them, support them and all. So every time I have to inform the board, I'm supporting this particular parliament member or a contestant. And if there's a conflict, I will be away from the meetings until this election is over. So that is one of the requirements. And the same way, if you have any interest, suppose my law firm is dealing with any issue with Centrelink or some government authority, if there are major decisions are made in my board about that government authority, I have to say, sorry, I am the legal advisor. I can't be in this room. I don't want to know what's happening. The other directors can take action. So I have to put it in writing. This time I had to, there was an election recently last month. I had to give all the members whom I was supporting. Even if I just do a Facebook posting, they expect us to give everything in writing to say that I'm supporting so and stuff. If there are any monetary involvement involved and all those things. So the same way, you have to disclose any conflict as a mediator. There can be personal, professional, financial that may constitute any conflict. And if you don't do that, and if the party has a justifiable doubt, independence or impartiality while conducting the mediation, they can go and complain and get rid of that mediator. Role of a mediator is also given there. It's only a facilitative role that where you just walk through and make them to take, okay, come with me, I'll show you what are the options and stuff. And I cannot impose, this is the best option for you, please go and accept this. I can't say that. These are the options. If you like, you take it. And if you don't like, you don't need to take it. Provisions have also been made for terminate the mandate of a mediator in case of conflict of interest. If you find the mediator is also having other interests with other party or outside organization, which is going to affect the mediation, you have provision that you can say that I don't want that. We have to terminate this mediator. Section 47 introduces the provision of community mediation. That's what Abe was trying to talk. Community mediation is a huge thing. It's not a new thing for us. We had the panchayats, and we would have seen in all the movies, they show how the elderly people in the village, they try to sort out stuff. Any dispute would affect the peace and harmony among the residents or families in the community. Anybody can be a mediator and sort it out. What are the benefits of community mediation? Anyone has any clue?
Better understanding of what their practices are.
Pardon?
A better understanding on the practices they follow. Like,
Yeah, if you're in a village, if you're an elderly person in the village, you know the practices that's been followed in the village. And you also know the families, what values they have and stuff. So we don't want to go to the police station. We don't want to go to the court. We'll sort it out ourselves and okay, what do you really expect? What is the issue? How can we sort it out amicably? So that will work out in a better way. The benefit is one benefit is that. The other thing is if you are in a community or you have a better social skills within that community. You don't need to be a big barrister or anything, but you know that your skills will suit to sort out any problem in the community because of your background. So these are the two benefits. What's the purpose of introducing community mediation?
Settle conflicts between the people in the same region.
With zero expense, you can settle conflict. Because if it's in a village and there's a grammar panchayat person, they won't charge you a big money or anything. So it's financially viable. And the knowledge and skill of that elderly person will work out very well in the community. So these are some of the stuff which you really enjoy. Role of a mediator is given as this facilitative thing, including the boundaries. The mediators have boundaries. What are the boundaries? What are the boundaries? If I'm a mediator, somebody comes with the banking mediation stuff, I have no clue of how does the bank works and stuff. I'm an expert in family, I'm an expert in criminal and other things. I say, no, I can handle it and come bring the case. And if I don't know the bank rules, if I don't know how the banks work, that's too much for me. So I should very honestly say, I can't handle it. We'll get somebody who is an expert in banking system. So you communicate with the parties and tell them that I'm not equipped to handle this. Sometimes we may have to get a subject matter expertise. Give me an example for that. You're doing a mediation in a family law matter. What kind of a subject? Psychologist for a child. You can get a psychologist, a competent person to play how the child-related issues can be handled. Privacy and confidentiality is given in section 22. What are the requirements for confidentiality and privacy requirement? Sensitive information. What are the sensitive information?
Marital affairs.
Is it a sensitive affair? Any sensitive information in a matter?
Religious.
Communal issues, race-related thing. When you talk about some issue in a village, two parties fighting, they belong to different race, and that is very sensitive issue, isn't it? Same way, religious matters. When you do the mediated settlement agreement also, that can be also challenged, as I said previously, on the grounds of incapacity of settlement by mediation under the law of India, corruption, contravention into the public policy of India. If it is against the public policy of India, if there's corruption involved, and if it's against the law in India, anything you have settled and you have signed, you can always go and challenge it and change it. Fraud, corruption, gross impropriety, impersonation is one of the things where you can challenge section 29(2). Section 43 and 44, shall be graded by Mediation Council of India. The providers will be graded. The infrastructure and facilities for the efficient conduct of mediators, register and file settlement agreements, amongst other function. All these things, how it has to be conducting the mediation services, what kind of a facility they have to have, what kind of a register they have to maintain. All these things are given in 43 and 44. 52 is about challenging again. If it's a case of an international mediation settlement agreement, the ground to challenge is the subject matter of the dispute is not capable of settlement by mediation under the law of India. The settlement agreement was induced or affected by fraud or corruption. It's a contribution to the public policy of India. These three grounds, you can always challenge an international mediated settlement agreement. Chapter 6 is about, again, online mediation setup. Online mediation shall be governed by the provision of Information Technology Act is also combined in that particular part. Areas that need some further clarification. Draft bill is certainly it's a good step, but still there are certain gaps and loopholes. It doesn't provide any details pertaining to the qualification of a trained mediator. At this stage, anybody can become a mediator. The capacity to mediate is also not defined. Mediation, the other thing is mandatory pre-litigation mediation mechanism would defeat the essence of mediation, where the parties are unwilling to mediate. If both parties don't want to think, you can't force them to go for mandatory mediation. That's not very clear. How do you assess that one? Further clarification is needed under each party to the extent agreed to by them could give rise to a possible conflict of interest. There may be conflict of interest arising if proper mediation process is not followed. It does not address as to what provision would govern the international mediation that takes place in India, but relates to non-commercial disputes that have arisen under the foreign law. If there is a issue arise under the foreign law, and what are the guidelines given is not very clear in the thing. The draft bill does not specify whether a mediation service provider can be a company. It says it can be anything, but it's not very clear about it. A domestic mediated settlement may be challenged on the ground of gross impropriety without making an endeavor to define the term or specify its counters. That means they need to very particularly see what is meant by that. The consequence of non-registration of mediated settlement service agreement have not been mentioned under the draft bill. What will happen if you are not registering the agreement? What will happen? We say that if it's registered, it goes. If you are not registered and then some stage it says, no, we didn't register, we just signed it because we were asked to sign. So what will be the consequence, and what those are not very clear. Okay, that's the basic things about the mediation bill which is proposed, and maybe when it becomes act, there may be more modifications and stuff, because we also given some suggestions, isn't it? Yes. So it should come. So any questions about the mediation bill?
Who will be assigned mediator?
Who?
Who will be appointed as mediator? That was the question.
So that's the thing, anyone who can be at this stage, they are not telling about the capacity of the mediator or the qualifications of the mediator. At this stage, anyone who is capable of mediating is good. But some stage they have to say, but they also say that on the other hand, everybody is trying to train mediators now. So is training a qualification? In that case, who will be the authority to, for us, In Australia, it's Australian Mediator Association. I'm a Resolution Institute. So all those things are capable of issuing the re-registration as mediators and stuff. But here, what is the position?
As like as an arbitration act,
Yeah.
anyone can be an arbitrator
Yeah.
unless they are prohibited under law.
Yeah,
Under the contract like this. In 2015 amendment, they brought in certain qualification. A lawyer who has 10 years experience, chartered accountant, cost accountant.
all become the arbitrator.
But anyway, that amendment is under suspension now.
Yeah, okay.
It is because these are the rules to be determined by the mediation council of
Council,
India and
yeah.
arbitration.
Arbitration council
So
of-
they will come and frame the regulation.
Yeah, once it's done, they will understand what's required for it. And see, it will go for further amendments like any other law. But at this stage, with the public opinion, people have fed information like we fed, and we also got, Inba Vijayan asked me to give some information and I gave in one of the meetings. So all these things will be considered, and there are other parts of India where the lawyers have given some kind of feedback. So all these things will contribute, and there will be a final shape for the bill. But I don't know when it.
But this mediation, like as in arbitration,
Mm.
now the Arbitration Council of India has called for applications for empanelment of arbitrators.
Okay,
So once it is empaneled, so they will be acting as an arbitrator. Likewise, the Mediation Council of India will call for the mediators. They will prescribe certain qualifications. Whoever meets such criteria, they can act as a mediator.
that is ICA, isn't it? In
I-
Indian
I-
Council
I-
for Arbitration.
India International Arbitration.
Yeah, I am one of the panel persons.
So
That was done long time back.
These are all the duties by the Mediation Council of India. So they will frame regulation for all those things.
But there are a lot of loopholes as such, because it's just a draft bill. So it will take its own. So how does it work? It goes to the parliament and gets approved.
After the standing committee has to file a report to the parliament, and the bill will be passed.
Any questions? Anyone who wants to know more? Anything?
How does in Australia the mediation works in case in the absence of any court-referred mediation, in case two parties agree at a settlement?
The conciliation conference is for the family law thing. But FDR, Family Dispute Resolution Providers, AIB does that all the time. Any family related matter, it has to go for FDR and then go to the court. It's a must.
But here what we do is we will have a mediation between the parties. Once the settlement is arrived, we will make it as a conciliated award.
Okay.
So that becomes enforceable.
Yeah, conciliation it's a court directed, like
Yes.
in a conciliator directed one.
You convert the mediation to conciliation.
Conciliation, yeah. We also do sometimes as the consent orders. If the husband and wife agree about the children and stuff, we make the orders and I file it in the court, so it becomes a consent order. Then it is registered in the court, they can't go back. Yeah. Any other questions?
Is there any enactment in Australia for that?
And we have the mediation thing, and there's mediation councils where we have to register every year. We have to re-register. To do that, you have to do a 10 points CPD, and all those things are there. For lawyers, we need to do 10 points, and we need to do 10 points for the mediators. For migration agent, you have to do 10 points, then arbitrator 10 points, and I have to do about half a dozen 10 points. Any questions, or you want to have a break? Just have a 10 minutes break, and then we'll do an exercise after that until the next thing. Yeah, thanks.
They're increasing the accounts in the case. Maybe 60,000.
It is specific for another bank.
Use it.
Example.
As you understand, by one of the issue on MPH is but issue on anyway, everybody will challenge பெரிய கிளைண்ட் தான்
சொன்ன உடனே புரிஞ்சுக்கிட்டாரு ஆனா
அவர் என்ன புத்தகங்கிட்ட வாங்கிட்டு போகாத வரையும் சந்தோஷம் போயிடுச்சு நான் சொன்னேன் அது போகும்போது பார்த்துக்கலாம் ஒரு போன் டேரக்டர் அப்ளிகேஷன் மீடியேஷன் அதுதான் எப்படி எப்படி அதாவது கமெண்ட் பண்றது
if they conduct investigation, some sort of experiment is arrived in my presence, it can go.
இதுல இவர் சேலஞ்ச் பண்ற கிரவுண்ட்ஸ் தான் சொல்றேன்.
Always
கிரவுண்ட்ஸ்லாம் சொல்றேன். கன்சென்ட் அவார்ட்ல there is no scope for challenge.
But acceptance are simple.
Impersonation, coercion, fraudulence, அதெல்லாம் என்ன மாதிரியான கேசஸ்
Always தொடர்ந்து வந்து
ஆர்பிட்டல் லிமிடெட் கிரவுண்ட் தான் இருக்கு 34. இதுல ஸ்கோப் அதிகம்.
எல்லாமே கன்செப்ட் compromise about it. Order content. That is
the central part is
same concept. The arbitrary. So it is after complying with all the requirements.
but in the body form.
நான் பேசும்போது ரெண்டு மிக்ஸ் பண்ணிட்டேன் கன்ஃபியூஷன் பட் இது செப்பரேட் இது ஏசியில் வந்து கேன் பி ஆர்பிட்ரேட் எனி ஆக்டிவிட்டி 6 ஐஏஎஸ்ல வந்து ஆக மாட்டோம். சின்ன சின்ன பிரச்சனை இருக்கும். சின்ன விஷயத்தெல்லாம் சால்வ் பண்ணி நம்ம அடிச்சு கடனை வச்சிருக்கோம் சால்வ்
We finished all the topics.
Okay.
Can I have a coffee or tea break?
Okay.